G'day everyone and welcome to video 4.2.2 for the Legal Studies guy. Our quote today from OG Mandino, always do your best. Goes without saying, pretty basic quote, but what you plant now, you will harvest later. So just again, a bit of that reminder of it's always best to do the work now and you'll get the reward later on. It's going to be a pretty quick one here, 4.2.2, which I'll talk about when we get down to the skill. But we are just looking at the roles of the Victorian courts and the High Court in lawmaking. It's the same skill that we've just looked at for Parliament, discuss the factors that affect the ability of Parliament and courts to make law. So discuss the factors that affect the ability of courts to make law. So we are just starting with the basic knowledge of what role courts play in lawmaking. Super simple one today, like I said. Basically, the courts or the court system has two roles. Their absolute primary role, so this is really important, number one thing that they do is they resolve disputes. I think we all know that. So judges will look at, or a panel of judges will look at the facts of a case. They'll look at the evidence that's presented to them. And then they'll apply the law to those facts to determine whether a party's actions are unlawful or not. Or obviously in criminal matters for indictable offences, the jury will then make the determination about whether the action is unlawful or not, but the judge will instruct them on what the law means so that they're better able to do that. So the primary role of the courts is to resolve disputes, pretty straightforward, but sometimes as part of this, they actually also make law. So a secondary role of the courts is that they can make law. So through the process of resolving disputes, courts, particularly if a dispute comes to them, if someone claims their rights have been infringed by another person, and it's the sort of matter that there's no legislation covering it and it's a new area that the courts have never heard before, the judge then has to sit down and decide whether someone's rights have been infringed. So basically, whatever decision the judge makes there will create new rules in that particular area that will then be followed in future cases. So this is the development of what's called common law. So if a judge makes or resolves a dispute in an area where there's no legislation and no previous decision, so a completely new area, they create common law. Or the other side of it is sometimes there is a law from Parliament, but it has to be interpreted. So maybe the law is a little bit ambiguous, or maybe it hasn't been written as well as it could be, or maybe it just, doesn't quite meet the situation fully, the situation that's actually arisen. And therefore, the courts will have to interpret the words in the Act of Parliament and apply them to the case. So that can actually build the statute up. It can change potentially the meaning or the intention of it. So number one, courts resolve disputes, but through the process of resolving disputes, they can sometimes also make law. When they do this, or how they make law, is the fact that the decision made by judges in resolving disputes creates what's known as precedent. So the reasons for the decision of a court, the ratio decidendi, establishes, so the decision in an individual case will establish a principle of law that is followed by future courts. AKA, if it's a new area or a new something that's never come before the courts before, the decision made by a judge will then be followed by future judges to ensure that there's consistency and predictability across the legal system. It also goes by the Latin term stare decisis, which means to stand by what has been decided. So it's all about predictability and consistency in the court system. These precedent, so these decisions that are made, can be binding, where they must be followed, or persuasive, where they're just influential on the decision. And this is all based on where the court sits in the court hierarchy. So a decision made on a particular area of law by the Supreme Court of Victoria is binding, so the same decision has to be made in similar cases on the County Court and the Magistrates Court. Similarly, the Supreme Court of Appeal, decisions made there are binding on the Supreme Court, the County Court, and the Magistrates Court. So decisions by higher courts are binding on lower courts within their jurisdiction. So decisions by the Supreme Court of the United States aren't binding on, say, the County Court in Victoria because different jurisdictions. So effectively, judge will resolve a dispute. It might be a new area It might be a situation that's never come before the courts before, and as a result, the decision that's made creates new common law, which then has to be followed in future cases. Now, obviously, people might appeal the decision to higher courts, and this continues to establish that area and develop that area of law. Judges have the ability to make and develop precedent, as I have just said, in cases involving a new issue, not covered by an existing precedent or statute. Cases involving the interpretation of a statute that hasn't previously been interpreted. So a court might have to decide what a word means. Or when a lower court has developed a precedent, judges in the higher court, if the matter's perhaps appealed or it's a similar case further down the track, judges can actually in higher courts develop this precedent and maybe overrule it and change the precedent for future cases. Our skill here is discuss the factors that affect the ability of courts to make laws. Now, the next set of slides is going to be on statutory interpretation in detail, and then 4.2.4 is the knowledge point is factors that affect the ability of courts to make laws. So it's actually got a list of 5 things that affect the ability of courts to make law. So we are going to end up with a situation like we did with Parliament, where we're going to look at factors that affect the ability of courts to make law, but also, because we're discussing, factors that don't affect the ability of courts to make law. So that's what we're going to get to. In the meantime, a dot point like this could just lead to, so the knowledge dot point could just lead to a question as simple as this. Explain the role of the courts in lawmaking. I don't actually have a sample answer written, but you'd be looking at the fact that it is a secondary role, and that they develop precedent, and a little bit of an explanation of what precedent is all you'd be looking at. Precedent was a really, really hot topic in the old study design, was featured on every single exam. So it's one to get your head around. And to help with that, there's a great link here. You can go to lawgovpoll.com/types of precedent, and it just explains binding and persuasive in a little bit more detail. 4.2.2 is done. Hopefully you know that the courts play a secondary role in lawmaking. Now we'll go into precedent in a little bit more detail in 4.2.4, and we'll go into statutory interpretation in a lot more detail in 4.2.3. Make sure to like, subscribe, leave feedback. Happy studying.